Welcome to the Meckey Estates podcast. This episode is for the homeowners who feel overwhelmed, confused, or unsure about when a home sale doesn't feel straightforward. Today I'm joined by Jacquelyn Villano, who has over 15 years of experience in the title insurance and settlement industry. She works across residential and commercial transactions. She deals with various situations such as liens, inheritance, divorces, and other complexities that people don't always expect. I wanted to have this conversation because title is one of the most misunderstood parts of real estate. And it's often where most fear comes from. It's not because someone did something wrong, but it's because they don't know what's normal or what's fixable. Today's conversation isn't about giving legal advice or teaching people how to do this on their own, but it's about clarity. What actually happens behind the scenes and why having the right professionals as a part of the selling process makes all the difference. Let's get into it. Jackie, thank you for being here. I'm really glad you're here.
Thank you. Appreciate it.
To start off simple, what does the word title mean for you, and what are the common misconceptions that people have?
Sure. Well, I think when we talk about title in the business from a real estate perspective, it's kind of a bit of an unknown. I mean, if you're in the arena that you're in, I think people are more familiar, clients are more familiar with it, but it's kind of this thing that happens behind the scenes. So to a regular homeowner or a home buyer, most people who live in their house and have lived in their house for many years have a title insurance policy, for example, and they don't even remember purchasing it at closing. The industry is so different now compared to how it was many years ago, but the word title itself is more so how the property is taken title-wise. I think a lot of times people get that confused with the deed, which is the document that actually records ownership. But it's not just the title piece itself. When we talk about title in the real estate industry, we're talking about settlement and also the background kind of investigation on the home. So on a higher level, what title insurance or title is we're talking about going under contract. It's the process of providing, from a title company perspective, an indemnity policy to the homeowner. So what title companies actually insure is their search. We're doing the search on the house, and it's not just lien search. We're doing an upper and lower court level search. So lien search, we're searching for judgments that have been recorded in someone's individual name on both the seller and the buyer. We're doing a tax and assessment search. So anything that would be open in the municipality arena, water, sewer, taxes, anything that's lienable that would attach itself to the home. And we're also doing sometimes the flood searches, tideland searches, wetland searches if they're called for on the property. Now, that's the basic stuff. Once you get into pre-foreclosures, estates, we kind of go a little bit further back. But in most cases, we're searching back at least 30, 40 years on a property, provided someone hasn't owned the home longer than that. But it's not just the searches. It's the settlement piece of it too. So now, it used to be different many years ago, title companies are taking on the responsibility of doing the settlement on the property. And what that means, if you're from a different state, you recognize it as being an escrow company. And that's essentially what we do as well. We're providing the searches, we're issuing a policy post-closing, but we're also the party that's going to be that neutral third party. We're going to hold the funds from the buyer. We're going to receive the funds from the lender if there is one, and we're going to make disbursements on everything that has to be paid as a result of closing. And that's really the bigger piece of it. When people go into this as a buyer, they don't understand that process. In Northern Jersey, unless you bought a home before, of course, in Northern Jersey, we still have attorneys practicing here for the real estate portion of it and representing buyers and sellers. Once you get down to lower central South Jersey, the title companies handle the settlement for the most part, and they don't really have attorneys involved at all except for drafting documents, the transfer documents. So it's a little bit different depending on what part of the state you're in. But for the most part, again, we don't provide legal advice to clients. We don't draft legal documents. We're there to set up and establish the escrow account for the buyer and the lender. We make disbursements, and we record all the documents that make the new homeowner the owner of the property at the end of the day, and providing them with a policy that protects their ownership in the property. So although title is this thing that people don't think about, maybe most of the communication is being done through their lender or through the realtor or through the attorney, it's ultimately the most important thing at the end of the day, because if you don't record that deed as a new homeowner, you're not the owner of the property. Right. And the title policy itself is the most important thing you can really have as a homeowner, because what it does is it protects your ownership in the property. And if you don't have guaranteed ownership in the property, right, do you really even own the property at all?
Exactly.
And the lender's going to want that as well. So if you're getting a loan here in New Jersey, if it's a private lender, they can make a decision not to have a policy, although it would be crazy not to. But any standard lender is going to require that a buyer pays for a title insurance policy on their behalf because they have a vested interest in the property as well.
Right. Yeah. So, I mean, you went like really in depth with multiple different aspects that people don't consider, sewer, liens, all that. Why is that title is one of those things that people really just overlook then if you see that it's so crucial to every aspect of that transaction?
I wouldn't say that it's mostly overlooked, but I think if you're a regular residential home buyer, and these things can come up on properties where they're maybe not distressed too, but on the whole, I mean, I've had very few transactions over 15 years that have really not closed because they've had such a crazy title flaw in the works there that we couldn't actually close or come up with a solution. But I think it's overlooked because, especially in northern Jersey, most of the communication is run through your legal counsel, and they're taking on the responsibility of really communicating with the title company and clearing up those title issues, especially on the seller side. So when we run a title search, it's mostly things that had to be cleared up on the seller side. If you're a buyer and you're purchasing in New Jersey, if you're purchasing cash, we can run buyer side judgments, but they have no bearing on issuing a title insurance policy because at the end of the day, we want the new homeowner to move in or purchase the property, investor purchase the property with only their new debt. It's mostly it has to be cleared up on the seller side. And I think because of most of the correspondence is run through legal counsel, the buyer and seller aren't having as much direct communication with the title company. It's just this thing that they have to have a title policy when they close. They recognize it as part of their closing costs. Hopefully, if they have legal counsel, that's being explained to them that you really should be purchasing this policy if it's cash, or if you're getting a loan, it's a requirement. And the title company is going to facilitate the closing for you. But I think that some people think that maybe their attorney handles all that at the end of the day. But if you have an attorney and a realtor up front, or a real estate representative that's explaining that process, we have a more savvy buyer now than we ever have. But as long as they know that someone is involved where they can reach out to them and that's kind of they're facilitating the whole process for them and they have a solid point of contact, they're recognizing that is going to be taken care of for them. So maybe they take a little bit of a backseat to it. And it's not the worst thing because when you have parties that people who don't fully understand the background of it, so to speak, or what happens behind the scenes, and they're getting so involved in it, trying to pick apart every little thing, it can kind of create maybe more of a headache than they even need to. And I'm fortunate that we still have attorneys in this northern New Jersey market that deal with a lot of this because it is a lot. It's a lot of emails. It's reading the title report, kind of pulling apart those things that need to be cleared up can really be a lot of responsibility. So for a homeowner or a buyer to go into it and have to take that on themselves, it can be quite a bit of responsibility and a bit of a headache.
Yeah, and it really shows in what you're saying, like your expertise. It's something that's crucial to have when you're going through a transaction, especially when it's an emotional transaction, which is something we see often in our business.
Yeah.
Having homeowners that are dealing with a bunch of things as is, and then they have to deal with the transaction on top of that too. It's really helpful to have someone like you in the transaction, guiding them through everything, and not needing to put so much of a burden on the seller or the buyer, but you're doing your thing. And leaning a little more into that, one of the most common things that we're seeing throughout the state is inherited properties. Right. We find a lot of homeowners, that are already dealing with losses in the family, and it's hard for them to really process a lot of things. And the last thing that they want to deal with is, a home sale that has, a bunch of issues and property that they're inheriting that they don't know what happened within the years, what hasn't been fixed, what has been fixed.
Absolutely.
It's a whole thing, and then you have to go through all the records, and it's very difficult. But from the title side, like, what is it that you find that comes with, inherited properties that people don't consider?
So I would say first and foremost, if you're either purchasing a property that has been inherited, or it's an estate sale, or you're selling a property that is the same, don't do it without an attorney. You have to have an attorney who practices real estate and is familiar with how these things are taken care of from a title perspective, because I have seen clients try to sell a property or purchase an estate sale, and just the sheer amount of searches and documents that have to be reviewed and attended to from a title perspective is very daunting, especially if you're on the seller side and you just recently experienced a loss in your family. Maybe it's not a property that you're familiar with. Maybe you're from out of state. and you're not familiar with how New Jersey does things, and you don't have any indication as to what's owed on the home, who paid what's gone into collections, what's been recorded as a lien on the property, it can be a lot to try to fill in the blanks. So that would be my first suggestion. But the top few problems we see come up with inherited properties, number one is, of course, chain of title issues. So when you purchase an inherited property or you're doing an estate sale, we're going to do the regular lien searches that we normally do, but we're also going to be doing a surrogate's court search. And what that is to confirm if the property's been to probate. So when you probate a property here in New Jersey, you're going to the surrogate's court, you're providing the documents to take care of that, to get the property probated, and they're going to either assign an executrix or an executor to the property who's going to have the ability to sell the home if there's a will. If there's no will, they're going to have letters of administration, which is going to give the authority to someone to sell the property. That's the first thing we need to make sure has been done, that the property has been probated. Now, if there is a will and the property has been probated, falling under that arena of title issues would be there's multiple beneficiaries. Maybe it's not just a cut and dry married couple, title passes to the spouse. Maybe you have multiple siblings. Maybe those siblings don't talk. Maybe the property wasn't even left to the siblings. One of them's the executor, but the property, the benefits of the property are going to be left to, a cousin or something like that they liked more than the kids. It sounds terrible and messy, but these things are all issues that can arise that can prevent a property from being sold or at a minimum delay it. So if you have multiple beneficiaries for a property, they all need to sign off on the sale of the home or at a minimum receive their funds that they're due from the sale of the home, or it's going to the estate and then the estate has to settle that afterwards. So tracking everybody down, making sure everyone's on board, making sure that the executor of the estate that's the person who really has the authority to sell. Sometimes, and one of the more common things we see pop up is, parent is the owner of the home. You have one child who's been taking care of them or is local. They pass away, but they're not actually the executor of the estate. Maybe they assigned it to someone else who doesn't live close by, and that person just assumes, well, I've been here, I've been dealing with everything, I'm the person who gets to sell it, but that's not the case. So for someone who's a listing agent, first and foremost, making sure that whoever's signing that listing agreement, or if you're coming in with an offer and you're negotiating with the seller directly, you want to make sure you're speaking to the right person who actually has authority to sell the home. So that's number one. And that can take a little time, but my suggestion to navigate that would be to confirm, again, who's able to legally sell the home up front. That's going to come to light during the title search, but best to find out about it early on so you know how to navigate that. And, a lot of times you're dealing with personalities and people maybe that don't get along as well. And unfortunately, estate sales can bring out the worst in people when there's money on the table in families. Second would be undisclosed liens or debts on the property. One of the more common ones would be if someone's gone into either long-term care or maybe one spouse, an older couple, one spouse passes away, and that person who passed away was the one really responsible for paying the bills, and then they go unattended. Second spouse passes away, and now you have maybe things that have gone to medical collections that have now attached themselves to the home in the form of a personal judgment. Of course, the mortgage not being paid, but those are the more common ones. And then, of course, like inheritance tax, things like that are required to be paid before you can actually close on the property. Generally, again, at closing, a lot of these items can be satisfied. It's more so about identifying them. So for an estate sale, always suggested that as soon as we can get that title search started, we want to get that started because we're not just relying on getting the lien search, but we're relying on the surrogate's court search as well to give us that information. So the sooner we can find out what's owed, we can kind of get to that. But when these liens or judgments come up, usually the executor of the estate or maybe the living spouse that is still dealing with the sale of the home doesn't always know what's to be paid. And then, of course, we have to order payoffs and get that taken care of. And then the third would just be missing information regarding the estate sale. So when you sell a property here that's an estate in New Jersey, title companies are going to require you to fill out an estate questionnaire, and that's going to require the executor, who's ever got the authority to sell, to provide information about the estate's liquidity, the value of the estate. You know, it's not just maybe the home that's going to be the estate. There's other things involved as well in that person's estate. So if there's not enough liquidity or not enough funds to cover the debts in the property, that can be problematic. But really just the sheer lack of knowledge sometimes of, you know, what is involved with the estate sale can be difficult for someone to get that questionnaire itself filled out. Maybe they don't have a tax ID number assigned for the estate. So all these things really can be not just fully prevented, but if you have an attorney who can walk you through that process, people need that moral support and they need that legal knowledge to fill that information out and to provide that information and to clear up those title issues, order payoffs before they can sell the home.
Right. Yeah. I mean, one of the key things that you mentioned is that we start early because the more early you start, the more options you have.
Absolutely.
So it's great to hear that, you know, for the people listening out there, that you're not stuck. There needs to be proper handling with these systems, and it's great that you have, you know, experienced it obviously throughout your experience through the 15 years of being in title. But you also mentioned one thing when you were talking about the inherited properties. One of the other big things that we see is tax liens and municipal issues. And then, you know, people have the tendency to hear those words and they think it's like it's already over and there's nothing we can do about it. What actually happens when a tax lien shows up on the file for the homeowner?
I think that when people look online, and especially if you're looking at properties that are distressed or trying to identify those properties, people see a lien, like that word lien on a property is this huge red flag. I mean, most people in New Jersey have a lien on the property. If you have a mortgage, you have a lien on your property. Yeah. Just like an easement. If you have public water or sewer, you have an easement on your property. But it's not the death of the deal, really, by any means. Like I said before, there's really few transactions that ultimately don't close because they have some type of encumbrance to title. So with a tax lien or maybe a pre-foreclosure property, when these items pop up, starting with the tax lien, if there's a tax sale certificate on the property, you know, it's not just straightforward where if you sell the property, maybe there's some, like a quarter, you're past due a quarter. They've essentially sold this tax sale certificate to a different lien holder now at this point in time, and that lien holder just needs to be paid prior to closing. So it would be no different than a regular transaction outside of the fact that the title company or, you know, the seller is ordering the information for like the payoff for the full tax sale certificate. We would reach out to the township. We would get a rundown essentially of what's owed on the property, if there's any premium that has to be paid. And we would just make sure that that debt is satisfied at closing and that lien is then discharged at the end of the day or released. Because again, back to what we were talking about with the title policy, title companies are ensuring their search. So anything that comes up that has to be satisfied, that's going to be a lien on the property, we want to make sure is taken care of before we issue a policy. And of course, when it comes to the tax sales, now if you have a mortgage on your property and you are paying taxes like everyone in New Jersey does, the lender wants to remain the first lien holder. So I know that going in, if there's a mortgage on a property, if it's a private mortgage, you know, maybe not so much, maybe they haven't paid close attention to paying the taxes. But if you have a standard mortgage on the property, you know, Wells Fargo or whoever it might be, Chase Bank, and you've defaulted on your loan, and most people that pay a traditional lender have their taxes escrowed. So they're paying their property taxes through their monthly payment, and then the lender's making quarterly payments on their behalf. If you default on that loan, the lender is going to continue to make the tax payment for you. So you have less of an issue where there being a tax sale certificate's going to pop up. So usually if we go in and we see that there's a mortgage on a property, we already know that the taxes are being paid because that lender wants to remain first lien holder. Right. But in the event that they don't have a lender or it's a private loan and they haven't been making the taxes and there's a tax sale certificate, it's just, again, about ordering that payoff early, making sure that there's enough funds or equity on the property to satisfy that at closing. So generally, it's not an issue. Honestly, it's more common than people think. People that have owned their home for many years that don't have a mortgage, but they fall behind on payments. A lot of times they fall behind on making their quarterly tax payments. And there's no tax sale certificate for someone who just misses like a quarter or two. It has to kind of go on a little bit longer than that for it to be problematic. But we want to we can look online, first and foremost, before you go into it. If you see online and you're investing in a property that there's past due taxes or a tax sale certificate, you can reach out to the title company and they can do a little bit of further digging. But honestly, if you just reach out to the township, they're usually pretty helpful in allowing you to know what needs to be satisfied in order to move forward and what's owed there. With regard to pre-foreclosure properties and liens, if a property is pre-foreclosure, depending on how far along, I think, like you said, people see a pre-foreclosure, there's a lien on the property. It doesn't mean that you can't sell that property.
Right.
And unfortunately for homeowners who are in that situation, they really have a lot more time to sell their home than they think.
Yeah.
If you get a foreclosure notice, you still have extensions that you can utilize, but most people don't kind of take action on that. And it's mostly because they don't have someone properly, like yourself, properly guiding them as to what their options are. The difference with the pre-foreclosure properties is generally there's other items that have been left unattended to, maybe other judgments that haven't been paid. But you're not dealing directly with the lender anymore. If it's pre-foreclosure, they've generally assigned it to an attorney or a law firm. So you're dealing with the foreclosure attorney. But same process as ordering a payoff. It takes a little bit longer, but you're ordering the payoff directly through the foreclosure attorney. And on top of that, you're not just going to have the principal interest. You're going to have back due taxes because the lender has been paying the taxes, and of course penalties and attorney's fees. But you're just dealing with a different party. For title companies, it's pretty common that we're seeing that a lot, depending on when you've purchased property. So coming out of that COVID era, we had a lot of people who, put their mortgage in forbearance or fell behind or maybe didn't fully understand what they could and couldn't pay. And people were pre-foreclosure. But like I said before, if that happens, it's not the death of the deal. It just means that maybe there's an additional party you have to deal with, or you have to make sure your team has the knowledge of how to work around those situations.
Yeah, of course. I mean, there's proper steps with everything. And the key, though, is to start early, So most people hear these words like the tax liens and also pre-foreclosure. They just put their head in the sand. I've seen it all the time with homeowners. And they're like, all right, whatever we can do, let's just move out, whatever. But there's a lot of options that we could do to help out family homeowners retain their equity, not let it to go to auction, and then lose everything, because that's the worst thing, worst outcome for everyone. Another distress situation that we find people go through a lot is unfortunately divorce situations. It's not emotional, but structurally, there's two homeowners that really have conflicting interests, and it makes the transaction very complicated. And on top of that, the court pressure and the timing, you have to keep up with deadlines and everything. How does that look on a title perspective?
So when we were talking about this podcast, we were talking about the one that, you and I had previously spoken about, that one transaction. Yeah. I think that it's not in the divorce situations. And I'm just thinking about this because I got off the phone with someone last week who was selling their house post-divorce, and they had to get a deed updated, and I had to speak to their ex-spouse. It's just, you have to just be, as you know, in our previous conversations, you have to just be sometimes a sounding board for people, because they're not generally upset with you if they're frustrated. They're just upset with the whole situation. Yeah. And real estate is sometimes you're just acting like a counselor as opposed to a real estate professional sometimes, and maybe that just kind of falls under that umbrella. But no different really than some of the other inherited properties or distressed properties. It's kind of the same few underlying issues, and that would be dealing with a couple different parties that really just don't see eye to eye and are making things sometimes more difficult than they need to be because it's fueled by emotion. But if you're dealing with a purchase or you're selling a house and it's post-divorce and the divorce has already happened, one of the more common issues we see come up is the ownership hasn't been properly reflected for the current marital situation. So I own a home with my husband. We get divorced. I retain the home as part of the marital settlement agreement. So I'm making sure that's properly outlined in the marital settlement agreement, but not just that. The more common issue we see is that there's a marital settlement agreement, everything's finalized, but there's never a deed done into the spouse who's going to remain in the property. And that becomes problematic because whether you go to either refinance or sell the property, however many years later, you can't without your spouse signing off on it. And, it's not always properly outlined in the marital settlement agreement. And again, a lot of attorneys skip.
And why is that? Why is it that they?
I don't know. That's the breakdown we see often. I mean, we get a lot of direct referrals from family attorneys where they're handling the marital settlement agreement and the divorce itself. But then outside of that, you have a 90-day window to file, post judgment, to file a quitclaim deed. I mean, that's generally the deed that's used, removing the spouse who's not remaining on the property anymore. And when I mentioned that 90-day window, it's important that it's done during that time because then you're exempt from paying that realty transfer fee in New Jersey. So if you're doing a dollar deed, there's no consideration amount. But you're going to have to pay realty transfer fee if there's an open mortgage. Now, if you do it within that 90-day window, there's an exemption. Once you're outside of that window, you have to pay 50% of the realty transfer fee on the open mortgage balance. So I'm not sure. I can't, I guess, speak to exactly why that's not always done. Maybe it's something that falls more in the real estate arena and not all family law attorneys are referring that out to someone. The good ones do, or they take care of that in-house and that's filed and everything's pretty much wrapped up all at once. But that's one of the more prevalent issues we see post-divorce is that deed wasn't properly done and we need to maybe reach back out, or they have to reach back out to their ex to sign off on that. And as you can imagine,
It's an awkward
it's just a
conversation,
really awkward conversation. Secondhand would be, of course, more common one we would see pop up would be undisclosed liens or debts.
Right.
So again, you're relying on one party sometimes in the marriage to pay the bills. And if that goes unchecked, when you go to sell the house post-divorce or during a divorce as part of a court order, some of these liens will come up on the property. Maybe someone wasn't paying a credit card, someone wasn't paying the mortgage, and the other spouse has no idea. At the end of the day, it's still going to get sold. Obviously, it just kind of throws some more fuel in the fire with how angry at each other people can already be.
And you'd be surprised. I mean, it happens a lot more
Yes.
often than you would think.
Yeah, absolutely.
There's just so much resentment with each other. And then, there's, back and forth about, all right, I'm not going to pay this. I'm gonna pay that. And then things build up. And it's just like by the time, you're selling the house, you're like, all right, where did this bill come from?
There's been some interesting ones. Some of the more interesting ones we've seen have been if someone, is gambling, down like like Atlantic City or something like that, and you see a judgment on a property or on an individual for debts of that nature, bail bonds.
Yeah,
that was one of the more interesting ones that I've seen. Of course, I've had personal situations like people I've known personally where they are, maybe on the precipice of being divorced and they get a pre-foreclosure notice and they think their spouse has been paying the mortgage for, the past year or so and they just haven't.
Right.
So again, it makes things more challenging, but you can, still sell the home if there's equity, especially in this market now. People just have more equity in their home than they really anticipate. And it's really rare that we see, first, second, third mortgages recorded on a property. It's pretty challenging to do that without your spouse signing off. So if you own a property here in New Jersey and it's a marital residence, you can't take out a mortgage unless it's like a private mortgage and your spouse isn't signing off on it, or you've done things, obviously not by the book. But it's usually things of that nature, like credit cards and other debts that have gone unpaid that can pop up, that can make things more challenging. And third, I would just say, again, the communication piece of it. So oftentimes with the divorce, you have two people that may hire their own, divorce attorneys, but then sometimes they're hiring their own real estate attorneys as well, or you have two realtors that are assigned to essentially handling the sale of the property. But just trying to make sure everyone stays in the loop equally is really important. So if we're, as a title company, communicating with two sellers of a property, I'm making sure that those people are both on the first email line, like one person's not in the regular, email receipt, and then the other person's in the CC. I want everyone to make sure they're receiving equal correspondence, and that can become challenging. It's just the general lack of communication because you're dealing sometimes with a timeline if it is pre-foreclosure or with the court, or maybe a buyer's getting a mortgage and they're up against a deadline for rate lock. So they have to be cognizant of a timeline for the buyer's sake as well.
Right. Yeah. And that's exactly what we face a lot with, Meckey Estates, where we have to deal with all these complex situations. And unfortunately, but fortunately, like we can help a lot of people, but it's never usually an easy situation.
No.
There's always something new coming up with each transaction, but that's why we bring people like you that really know what they're doing, and we can make sure we can get this done clearly and in a timely manner. And one of the bigger surprises that people get is when they discover like an old mortgage judgment,
Sure.
like you were saying, that they thought they already taken care of. Is that something that you see commonly happen? And why is it that happens?
Absolutely. So with the older mortgages, I mean, generally something has to be at least 30 years or older for
Right.
a title company, maybe to consider it ancient. Where if we run a search, we're doing a search that's at least that length, unless for some reason the current homeowner has like a title insurance policy, or we handled the last purchase, so we know that we insured the last purchase. We're okay to kind of start from that point moving forward. But people that have owned their home longer than that, there was this period of time years ago where people paid off their mortgage and the lender wasn't necessarily sending that discharge of mortgage to the county directly to be recorded. They were sending it to the homeowner. And the homeowner was thinking like, wow, this is great. I've paid off my mortgage, not realizing they had to take that discharge and go to the county and record it. So it remains a lien on the property. And, maybe they refinance after that. Maybe they haven't. Generally, it's caught during the course of a refinance. But the common misconception people have is, well, why is this coming up now? I've refinanced my home. When you sell your home, one of the things that an attorney is going to ask you for is a copy of your title insurance policy. And that's going to indicate that when you purchase your home, everything from the time you purchase moving backwards, and that's the difference between a title insurance policy and a regular insurance policy. Most insurances insure for future instances, and we insure for past instances. So they provide their their owner's policy for the title company, and that indicates that everything prior to that was taken care of. When you refinance, you don't get a new owner's policy. You get a lender's policy, and that's not for you. That's for the lender. So when you go to sell your house, any of that debt that you've incurred during that time is going to come up. And even if you've paid off your mortgage, but a discharge wasn't properly recorded, it's going to show up in the county as a lien of record. Now, a couple of solutions to that is, either it's so old where the title company can just consider it an ancient mortgage and we would omit it from the title insurance policy as an issue. Second would be that until you can obtain a payoff, generally the issue with these is that the bank has gone out of business or they've sold to another bank, and trying to track it down can be problematic. And title insurance is kind of, the chain of title is about connecting the dots for us. We have to make sure that everything checks out. And it's not that title companies want to be difficult or anything. It's just that we have to make sure that the buyer can close. And when they go to resell that property or refinance, it's not going to be a problem for them moving forward. So tracking those banks down, finding out who can give us a clear indication as to who has a payoff, or they can produce a discharge that can be provided to the title company. Even if it hasn't been recorded yet, it can be executed, provided to the title company, and we can record that when we record the new deed. Third would be that we hold an escrow until that payoff or that discharge can be tracked down. And generally that looks something like 1.5 times the face value, depending on how old it is. So obviously if it's a really old mortgage and it's a small amount, it's not going to be problematic. But if someone bought their house, got a loan within the last 10, 15 years, paid off their mortgage and it wasn't discharged, it can be a little bit more hefty in that maybe there isn't enough equity in the home, especially if they have a current mortgage that they have to satisfy. And then lastly, kind of last resort would be that if you've exhausted all options, I wouldn't say the last resort, but tracking down, using a company to track down some of these discharges. There are companies that title companies have connections with where their whole existence is to reach out to these old lenders or, kind of follow the chain of who's purchased what from what bank and track down that discharge. They charge a fee for it, but generally they're pretty successful in tracking that information down. The absolute last resort would be to take some type of court action to extinguish that lien. So you would file a quiet title action. Unfortunately for that, it does cost a little money because you have to hire an attorney to do that. And not all attorneys are, from real estate perspective, are familiar with that. But what they would do is they would essentially present a case to the court that you've tried to extinguish all options to get a discharge, get a payoff for this mortgage. Bank's gone out of business. They sold to this company. The lien holder is no longer alive or no longer in existence. Yeah. And they file a motion to remove that from the chain of title and extinguish that lien. And usually, if the evidence is there, it's successful. But the title company will usually hold an escrow in the interim until that's taken care of. So that's really the last resort. But there are options in order to take care of that. But you need to make sure you have a title company where, we're speaking about it here, but also it's not the title agency at the end of the day who makes all these decisions, it's the underwriter. And most of the title companies deal with a lot of the same underwriters, and their underwriting counsel can make a decision on that. So having a direct in to speak to them about that as to why they will or will not insure that and what the options are is important.
Yeah. And not to scare anyone, but like what happens when these issues aren't identified early on? Can you touch on that?
Absolutely. So one of the most important things that you can do is when you're entering into a transaction, you go under contract, is getting the title search ordered right away. Because it might not just be, okay, the search comes back in a couple of days. If there's a really old mortgage, great, we find out about that. But we need time, or the seller needs time, to reach out to the appropriate parties in order to get these discharges or payoffs. So, if we find that an attorney's waiting until maybe after a mortgage commitment is received to order a title search, that could really put the deal in jeopardy of closing on time, because you don't know what's going to come up in the search until you really start digging into it. And then when we find that information, how long is it going to take to reach out to the parties in order to clear those items up? So really, the sooner the better. There's no downside to getting it ordered early. It gives the lender ample time to clear that condition. The title company is going to be a requirement for them to issue a commitment, and for the seller to really spend that time investigating what needs to be tracked down, or their legal counsel. So the earlier the better. Absolutely.
Yeah, I mean, as she's saying, there's a lot of moving parts with this. So guys, get it done early. And, that coordination is what really changes everything. So the whole goal with this is to have no surprises throughout this whole process. All right, so if you were to summarize everything that you talked about throughout this conversation, what would be the key takeaway for homeowners out there?
Absolutely. So key takeaways would be early intervention with your team. So if you're not familiar with what you need to investigate on as far as liens, et cetera, debts on the home, or who has to sign off on what, speak to your trusted professionals about this. Make sure that you have a team in place that, you as a homeowner, you're not expected to know all these things. You're not the attorney, you're not the real estate professional, and that's why you hire the team of professionals to do that. What's most important is just having your team in place. Everyone says that whole, cheesy thing, like who you work with matters, but it's really so true at the end of the day, because being able to reach out to someone and you're like, oh my gosh, I'm in pre-foreclosure. I have this, I have that. I was told that I have this mortgage and I can't track down this discharge. It can feel so daunting. But if you have a team of professionals that's like, listen, we have a resource for this. Here's the action steps that we have to take moving forward in order to get this taken care of for you. It can be very disarming, and it can really put someone at ease. So having your team in place, early intervention, make sure that if you are a homeowner, again, title is really being ordered on the buyer side. But as a seller, reach out to your real estate attorney, your title company about investigating these items early on, because then you can go into the sale of the home feeling like you have all the options on the table, everything's going to be settled for you, and you have your answers moving forward. And then lastly would just be open and communicate with your team about these things. When you go into a transaction, whether you have the buyer or the seller, withholding information about items that can hold up the sale of a property is never beneficial, especially when it comes to title issues. The more information you have, the better. And if you're an investor or a buyer of a home, your title insurance policy and all these things that you get at closing, you get all this paperwork thrown at you, keep that information organized, especially if you're someone who's a flipper or an investor, because when you go to sell the property, you're going to make your life a whole lot easier. From some perspective, someone who's purchasing in an LLC, have your LLC docs in order as well. Make sure you kind of keep all that stuff information organized. But the more organized and more open flow of communication you have going into a transaction, the better. It's just a win-win situation when that happens.
Yeah, when someone sells in Meckey Estates, coordinating with professionals is key. Jackie, for anyone that's out there in the industry or that want to learn more about the title side of things, where can they find you?
Sure. Well, the best way to reach me is on my cell phone. But generally, I would say cell phone, email. We work the same hours that all the industry professionals do, and that's usually weekends when you guys are meeting with clients or after hours, and of course regular business hours as well. But my cell phone is definitely the best way to reach out to me. We really pride ourselves on being very responsive, and whether that's early in the morning, later at night, weekends, we want to make sure we can jump on calls with clients and yourselves to kind of put them at ease. So a lot of times we're talking to people before the transactions even happened and kind of preparing them for that. But that's really the best way to reach out to us. We have several offices throughout the state of New Jersey. We handle transactions all throughout New Jersey, from distressed properties to regular residential properties as well.
Right. And for any homeowners that were listening throughout this conversation, feel like any of the points have resonated with them, you can always reach out to myself at Meckey Estates via our website at meckeyestates.com, or call us directly at 973-315-6705. We'll also have Jackie's information down in the description if you have any questions on the title side of things. The key is that if you act early, the more options you'll have. So if you feel like you're in a tough situation, just give us a call. We can help you out with whatever you're going through. Make sure that you get the most favorable outcome. And yeah, see you guys in the next one.